With no more ado, let's go.
Right, we are live. Good evening. Welcome to another live episode on Disqualified Dads. Today's is a very special episode. As you can see, I'm not in my studio in London. I'm deep north in the middle of the village somewhere in this little studio, little classroom. We're here together. He's not on the other side of the screen. He's here with me together, and we will be answering your questions. None other than my co-host, Mr. Bentley Ryan.
How do you do, folks? How do you do? Welcome to the Midlands. I appreciate Farouk has been in the Midlands with me all weekend, and it's been something of a revelation for him.
Absolutely.
He didn't realise there were so many trees in the country, and so that's concerned him. And he's been frightened by the lack of traffic. But there we go. That's the upside or downside of the civilised countryside.
Look, the countryside is lovely. I'm not knocking it. It is actually very nice looking at all this greenery. But I just want to highlight, I am the only brown guy that I know around here currently. So, the only brown guy in the area.
That is true. That is true. That's not that's just how it is. But yeah, that is true. You are the only brown guy, using your phrase, within a good few miles of where we're currently sat.
Absolutely, absolutely. Now, guys, just want you to know we are here live every Sunday at 8 p.m. as promised. So here we are today, going to be answering your questions, trying to tackle anything you have on the family court front. And also, yes, Mr. Ryan, is there any specific things we want to cover today? Do you want to talk a little bit about why we're here, what we're doing?
Yeah, let's talk about that. Let's talk about why it is that you've come out of the south and travelled north into the unknown in order to join me here in my studio, which makes a bit of a change. I have to say, I've been building this studio for the last probably 4 or 5 weeks, really, on and off, because obviously it can't get in the way of the day job. But we've been building it on and off, and we're there or thereabouts. Still a bit more work we want to do with it. But the reason we've built it is twofold. Number one, in order that we can carry on doing what we do already in terms of shorts and the videos that we do on our YouTube channel and the stuff that we put out on Instagram and Facebook. So one, we're going to ramp that up significantly over the next few weeks and months, quite deliberately. So that's issue number one. But issue number two is much more interesting. Tell the people about issue number two.
See that here? See that right here? Now, over the last sort of say last month or so, the last couple of months, we've been talking about this roadmap and the fact that there are many parents that end up in the family court system without any representation, any idea. They have no idea what they're doing. They're completely just muddling through. So after many discussions, we thought about it, put our heads together, and decided to come up with a course, basically a family court training course that gives you a roadmap, gives you the training, the coaching. It will hold your hand and walk you through the system without having to employ a McKinsey or a solicitor, barrister, anything like that. So instead of going on your own completely, this is the first tier up, option one, that you can take to help you get through the system. It won't cost an arm and a leg, but it is a paid product. And we are putting time, effort, investment behind it so we can get this product to market ultimately. So that's why I'm here working on this.
That is why we're here. So we've spent this weekend just testing some of the mechanisms we're going to be using, and just making sure that we have a set of principles that will work for this product, because this product is quite important. Apart from the fact that we are going to be helping people who want to, either because they can't afford any other option or because they've got the front to want to go it alone through family court. So we've put together Family Court Mastery in order to allow people to do that. But there's a second little twist to the tail, which is this: because Family Court Mastery is a paid product, and it is cheaper than using a dedicated Mackenzie friend or indeed using solicitors. It is significantly cheaper than both. But we wanted it to have a give back to it. We wanted to be able to give back, and so what we've done is within the fees that are associated with the family court mastery, a percentage of those fees, and at the moment we think it's probably going to be 10 to 15%, but a percentage of the fees that are received will go into a bursary fund. That bursary fund will be held by Mackenzie McCarve, and we will use that to support people who do not have the means to go solicitor, do not have the means to go Mackenzie, and do not have the means to go through our training course. Consequently, they are completely exposed. And you know as well as I, with the state of the nation, with the state of the economy, with the state of the cost crisis that we're currently in the middle of, there are lots of people out there who are very exposed. So we wanted to help those people. We didn't want to leave them high and dry. So we've created the bursary scheme, which sits within Family Court Mastery, whereby a percentage of the fees that are paid by the people who are taking part in the mastery training course will be set aside and will be used to assist those people who are in real need, because nobody should go into the family court system unaided.
Right, yes, guys, just one quick question, just any chance of volume. What we'll do is we'll speak a bit louder, just let us know if there's any improvement. If there's any issue with the audio, just highlight in the comments, and we'll make an adjustment as needed. But yes, just want to reiterate like what Mr. Ryan said. This is to help those at the bottom. This bursary will be built up to help those at the bottom who have absolutely nothing and no one, and can do ultimately, they can effect no change in the family court. So we're going to try and build this up to support them. You just bear with us while we're still trying to figure out this volume.
Yeah, we'll figure out the volume problem, but we'll do that by shouting.
Yeah.
As I say, because we are still in a bit of a test bed in here. It's a bit of a test bed. So that's why Farouk is up here, is because, as I say, we are building this product at the moment, Family Court Mastery training program being built at the moment, and it will be available within the next 4 to 6 weeks. That's the plan. It will launch in the market within the next 4 to 6 weeks. But you will, if you're monitoring social media, if you happen to be a big advocate on Facebook or you follow Instagram, you will start to see over the next couple of weeks lots of references to Family Court Mastery, lots of little sound bites and little tasters of what people have in store when they come and join the Family Court Mastery course.
Right, so I'm going to highlight the first comment of the night. Adam, Mr. Egg, the hero helping dads. You are correct. That's a fact that you've just stated. I am a hero.
Sorry, why is that?
I am a hero.
But is that not a reference to me?
Oh, he's talking about me, bro.
Why are you talking about you?
So I look like a hero, don't I?
Well, yeah.
I'm in shape.
Yeah.
I look good. Do you know what I mean?
Okay, all right, move on.
Camera.
Yeah, fine. Move on.
That's a fact, Adam. That's a fact. You just stated a fact. I'm not saying it. You're saying it. Oh, there you go. Look, big up to you both, pioneers in the game. There you go.
Oh, there we go.
You.
All right, the moment's been pulled back. The moment has been pulled back. Anyway, good evening, folks. How are you? How's the week been?
Right.
Family Court has been as chaotic as ever, and the week ahead promises to be no different. So we're with you. Let's see what you've got to tell us.
Yeah, let's tackle some of these questions. Right, Hungry Hippo, highlights. Love the new setup. Yeah, it's a work in progress. We're still trying to get it right, but we're getting there slowly. Right, for H, court have said no cross questions as both LIPs. Any advice, insight, knowledge as to what to expect, please?
Okay, so you're going into your final hearing, and the court has said to you, let's just clarify this, that because you, both of you and the other side, are both litigants in person, i.e. you have no representation, the judge has said to you there will be no cross-examination, which means neither of you have opportunity to ask questions of the other. Without knowing your circumstances, I don't know whether that's puts you at a disadvantage or not. Let's just work with what we've got and say that you're not going to offer any cross-examination. So this is what you have. What you are going to have, because the court can't deny you this, is you are going to have the opportunity to make submission, and we've talked about this before. So this is an oral argument that you give. It's a statement that you give out loud. You can prepare it in advance, always prepare it in advance, and read it out. And it gives your side of the story. It makes any points that you want to make, ideally points that you have made previously in the proceedings. Court gets very uncomfortable if you suddenly produce a fresh allegation or a fresh criticism out of the air at the final hearing. So comments that you've made before, bring those into your final submission, and then close your final submission by telling the court exactly what it is that you are trying to achieve and why the court should allow you to achieve it. Important, very important part of the process, because you have had the opportunity for cross-examination removed from you. The submission is important. Spend some time preparing it, spend some time thinking about it.
Right, Hungry Hippo, I hope that answers the question. Just in the comments, put down if you heard it clearly and what the sound is like, Hungry Hippo, on your next comment. Right, this was from earlier. Right. 5-star, good evening, lads. Setup looks smart. Yeah, we're getting there. We're getting there. Right, Mr. A, great to you guys. Question: my wife provided false information during a court hearing. So my wife provided false information during a court hearing. This has had a big impact on their schooling and also my contact. How firmly will the court see this?
I suppose the obvious question is, does the court know? Is the court aware of the fact that your wife has provided false information? Have you had the opportunity to tell them? And unfortunately, you can't just tell them. You need to be able to substantiate it. So you need to be able to explain to them why it is that what she has said is false information. If you haven't had that opportunity yet, you need to make sure that at the very first chance you get, you need to make your feelings known. Because otherwise, what will happen is the court will go forward on the premise of whatever it is that mother has said and take that as fact. And they will base the decisions they make and the resolutions that they put before you on the premise of that fact. So you need to seize the opportunity to correct the court as soon as you possibly can.
All right. Okay, I hope that answers the question, Mr. A. Right, Mr. Cal, can I still claim P alienation if I'm going to get at least one finding made at the fact find?
The reality is, as I've said before many times on fact finds, courts will always find something, find one of the allegations to be true on a fact find. I'm guessing from the way I'm reading your question that the allegations being made are against you. The question I would ask you, Kai, is whether you have raised the issue, the subject of parental alienation already. Otherwise, we're going to have that difficulty that I've just touched on, which is raising fresh themes when you're a good way into the process, because the court wants to know why it is you haven't raised them previously. So, let's assume you have mentioned parental alienation already, then once the fact find is over, the next stage is highly likely to be CAFCASS to get involved and review those findings and interview you and interview the mother. There is your opportunity to raise the issue again of parental alienation and explain why it is you feel that way. So to answer the question, you probably do still have opportunity to talk about parental alienation, but be aware, as I've mentioned many times before, the court is uncomfortable with parental alienation, so be careful how you couch it, be careful how you explain it, and be careful on the angle you take on it, because otherwise the court will become quite dismissive.
Absolutely. Right, let's move along. Before we move, do you reckon, is that just remote to zoom that? That camera.
Zoom it in and out.
Yes, zoom it in a bit. Yes,
that one.
Okay. Sorry, guys. Just
we're learning as we go. It's exciting.
There you go. So coming over.
Yeah.
A little bit.
Learning as we go.
So now it's a better picture. Right, here we go. Right, Mr. A, I remember this case, the finance. Right. On a finance matter, they have not stated gold. They have, however, or they have, sorry. On a finance matter, they have not stated gold they have. How can I prove this?
Okay, the issue of gold, it tends to be an issue that's fairly unique to the Islamic community. You have to say the Asian community. It tends not to be something that rears its head on my side of the fence, but it is a big issue. If they've not stated that the gold that they have, your only opportunity, well, actually, no, you have two opportunities. Firstly, play the Asian community card. The court will be acutely aware that it is very normal in Asian marriages for there to be gold by way of a dowry or a gift or whatever. So play that card and say, it would be highly unusual if there wasn't any gold. Secondly, and I trust you have this, photographs of the gold. And that isn't to say that you've laid the gold on the table and photographed every item, but there will be photographs from the wedding day where the gold is being worn. There might be videos from the wedding day where the gold is being worn, and that is your big hang. If you can access those, the photographs or the video, you can access those. That is your opportunity to demonstrate that there is gold in the mix and it needs to be considered.
Yes, absolutely. And if the court or a judge is watching, I ain't got no gold, I ain't got no money, I ain't got no gold, I'm practically skinned. Just putting it out there, yeah. Done from the Asian community, I ain't got none of it.
That's true. That's true. There's certainly. I mean, we've been here all weekend. I have not seen any gold at all. To be fair, I've not seen any money either. Anyway, moving on.
It's not barely got money to eat. You know what I'm saying?
Oh, stop it.
Right, 5-star. Farouk is more like Alfred and Bentley Ryan is Batman. Listen, hold on. Let's just slow down. Back to Robin. There's Batman, Robin, young, fit, trim. Alfred, bro. Come on, man.
No, I don't know. I think Alfred the Butler is a quite appropriate. Well, yeah, no, I quite like that. I quite like that. I was 5-star on this.
That's cold. Listen, when you ring me again, 5-star, yeah, listen. I don't think I'll be picking up too soon. That's cold.
So precious. So precious.
There you go. You are both one superhero. Let's move along from this.
Move on.
Enough of these superhero analogies. Let's just move along from this now. Right, family court is definitely chaotic and unpredictable. When Farouk said treat it like a circus, he wasn't kidding.
That's very true. And without, I know exactly what 5-star is saying here, because without delving specifically into his case, 5-star is a client of mine. We have been in court this week, and it was ridiculous. It was ridiculous because the court allowed an adjournment to take place. I'm not going to talk through the details, but the court allowed an adjournment to take place, which I don't think was entirely appropriate. But it just meant a total waste of time. It just meant that myself and 5-star stood in a court corridor for a couple of hours waiting for nothing to happen, and then nothing happened, and then we left.
Sounds familiar.
Yeah, so the court system is chaotic, it is unpredictable, it is undoubtedly a circus. And it's just not showing any signs of getting any better. In fact, it's probably showing signs of getting worse.
Yeah. Yeah, listen, I just want to highlight the point again. So I had a hearing, near enough, 2.5 years ago now. First hearing for the non-mol order, which was, it was actually 3 months after the order was served, which was bizarre, we said at the time. And normally they give you 6 to 8 weeks and you got an answer. Mine was 3 months for some reason. So I turn up with all these hopes and dreams of someone listening to me and some justice. We get to the window, we were told, it wasn't even postponed. There was no judges. They said, we have no judges to see your case today, so just go home. So look, very normal, very normal.
Yeah, very much so. Very much so. It's not great. It really isn't great. And from my point of view, obviously, I'm in court, 4 days out of 5, 5 days out of 5 sometimes. And so it almost reaches the point of embarrassment for me. Because I'm thinking, this is my workplace. I bring clients in here And I bring them in here with some assurances that this arena is there to support them and assist them in whatever it is their conflict is or whatever it is their issue is. And so it's quite embarrassing when you can't even get past the start point.
Yes, yes.
You can't even get past the start. That is incredibly embarrassing.
See, but the thing is, this 5-star, yeah. Like I said, I think we spoke on the phone. If you are who I think you are. Now, I've been waiting 3 years. For my non-null order ran out before I had a hearing. The child access, we're still waiting for the first hearing. It's been 3 years. We're just waiting to get that off the ground. So the fact that you're getting hearings every 3 months, you're in a good place. You've got time. Remember this. Focus on the good stuff. Focus on what is happening. Because, like I said, 3 years no hearing. You're getting hearings every 3 months. The other thing is this, which I keep saying, treat it like a circus. One of the 10 commandments of family court is don't take it too seriously. Because when you walk in too emotional, expecting this great outcomes, when you get let down, it sets you back by weeks, if not months, in your journey of resilience. So what I say is don't take it too seriously. Treat it like a circus and expect nothing. That's the mindset that you go in with. That way you do not burn emotional fuel. Because what happens in court is eventually fathers, they emotionally burn out and then they give up. Now, me, I can carry on fighting for another 3 years because I've got reserves, plenty of emotional reserves, because I've not burned them out. I'm not expecting anything. I don't take it too seriously. So I have plenty of reserves. But a lot of fathers I know, they burn out. So do not burn out. Do not take it too seriously. You roll with the punches. Sometimes in a fight, you have to take a couple of rounds off while you're figuring out what you're going to do, how you're going to fight. So that's how you're going to treat it, yeah? Don't take it too seriously.
Very true. Very true.
Right, Mr. C, good to see your name up here. Whilst far from set in stone, a lot of talk about defence spending required at the detriment possibility of other spending cuts across the board. So who knows, sadly, the family court may get slower. Yes.
Oh my word, we've just got political. We've just gone and got political. I cannot believe it at this early stage of the game. We're now talking about defence spending in this great land of ours. Next, we'll be talking about benefit cuts. Okay, all right. Here's what I say on this. Putting aside defence spending, which is not really my realm, but as a nation, as a country, we are in a mess. Our spending, our centralised spending, is chaotic, to say the least. I don't believe, and this is quite sad, but I don't believe there is anybody in Whitehall who actually has the full picture in order to be able to make the right decisions. I think we are being very sporadic in our approach. I think we are being incredibly reactive in our approach. And I think the sound bites of social media are more important to the current political population than actually the reality of making a difference. So I think your point is a very valid one. We have got to increase our defence spending, apparently, as a result of obviously episodes around the world, episodes which have taken a significant upturn in recent weeks as a result of the introduction of a new player on that stage. I will say no more. As a result of that, there is a pecking order in terms of how cash is spent out of Whitehall. My view is that the justice system is some way down that pecking order. And if you then look at the justice system and accept that within there you've got the prison system, the criminal justice system, the civil justice system, and then the family justice system, I fear that the family court is probably at the bottom of that list. And I think that people are turning a blind eye to it because there are greater issues further up the list. The prison system is in absolute chaos and overpopulated, and we just don't know what to do about that. The criminal justice system is incredibly slow, incredibly under-resourced, and is making some bizarre decisions. If we look at some of the high-profile cases that have run recently, making some bizarre decisions. The civil justice system is weighed down by a lot of corporate litigation, which takes months and months and months and often years, which clogs that system up. And finally, they get down to us. Finally, they get down to my workplace, the family court, So I think you're right. I think we are in trouble, and there's no money coming our way anytime soon. We've got to try and live with what we've got, but what we've got doesn't work now, and it's certainly not going to get any better without somebody taking a spanner to it.
See, let me take a different approach to this. See, when people get political, which I understand the point Mr. Bentley Ryan is making, but let me highlight the points to the average man. So how does all of this affect the father? How does this affect us? How does this affect me and you, those in the system, those effectively left here, left for dead? I mean, left for dead, right, ultimately. Now, no help is coming from government, no money's coming. And generally, even if the money was coming down to the family courts, let's face it, the fathers are still fighting an uphill battle. So my position is this. I'm not relying on the government to change my life. I'm not relying on the council. I'm not relying on the family. I'm not relying on anyone. I'm relying on me. I'm relying on myself and my actions and my daily habits. And I'm inputting into me, into developing myself. So I'm not relying on anyone else. I don't hold accountability anywhere else but me and what I'm doing. And this is the mindset that I'm talking about. The moment you're blaming government, you're relying on this, you're relying on that. This is the problem. Everything you're relying on is external forces. How about you rely on yourself? How about you educate yourself? How about you put yourself into a position where you no longer rely on all of these systems and processes? Now, we are stuck in the family court. We need to get through it. We are putting the information and knowledge out there. We are putting the courses out there. We're putting all the mechanisms out there to help you get through this. Once you get through to the end of this journey, you should have enough knowledge now to know that you do not need to be in this position ever again. You do not need to rely on anyone else again. If you develop yourself and elevate yourself and rise into a person that is no longer a victim, it's a mindset. So all of these places, sort your finances out, sort your health out, sort your life out, and start living life on your terms. This is what I'm getting to, the next paradigm, to elevate in life generally, instead of life happening to you. So the politics is a way, or it's a paradigm where people live under and operate under. I'm saying we need to go above that. We live in our own paradigm. We curate our own environment and create our own future. So that's what I'm talking about. So it's a different mindset. And that's where we're headed. Right, we have a very good question. What is an addendum report?
An addendum. What is an addendum report? Okay, all right. Let's talk about an addendum report. If Cafcass, and I assume this report is coming from Cafcass, it can come from the local authority. So if either of them, either local authority or Cafcass, has done a report in your matter, perhaps a section 7, perhaps a section 37, and the court decides that there's been a slight change, there's been a development, there's been some new information added, and they'd quite like that report to be updated. So what they asked for, instead of doing the whole process again, instead of doing a whole new section 7 or a whole section 37, the court asks for an addendum report. So the court gives Cafcass, or the local authority, a very clear direction. These are the questions we want you to answer in an addendum report. And that might be some information gathering, that might be a conversation with mum and dad, or indeed with the children. But that is an addendum report, so it's an add-on, it's a bolt-on, it's an extra bit to reports that are already within your matter.
So
that's it. That is
right.
it. That is an addendum report.
Mr. Lewis, hope that answers the question. Right, Mr. A, thanks for clarifying. The court do not know my ex gave false info to court. My solicitors will hopefully raise this on the next hearing. If the ex is proven guilty, will help my case RE custody.
Yeah. If you can demonstrate to the court that the mother has been dishonest in the face of the court, and that is the phrase that we use. So if mother has been dishonest in the face of the court, that will not go down well with the judge or with the magistrate or whoever is presiding over the matter. So it is quite important that your solicitors put forward a very strong argument to demonstrate that the mother has been dishonest in the face of the court, because that will assist you, because what that will do is it will change the dynamic. Now, having said that, it is a given in the family court that people lie. The family court accepts that parties, mum and dad, lie whilst in the family court, and they do that for a number of reasons. They do that in order to try and present a different narrative to reality. They do that because they're ashamed. They do that because they're frightened. They do that because it is a subtle attack at the other side. So there's a number of reasons why people lie. So mother has presented some false information. The court will not be overly surprised by the fact that she has lied. You need to highlight the fact that she has lied. And the court's view will be, we don't like it. It does slightly change the dynamic because now we have this view that mother is not entirely honest and isn't entirely driven by integrity, which is going to assist your case in terms of what you're trying to pursue with your children. Is mother, let's just answer the ultimate question, is the fact that mother's lied immediately going to make the court say, do you know what, those children need to move from this side of the court to that side of the court because you're a liar? Is that going to happen?
No.
No, it's not.
No,
it's not. No. But it will assist your case and it will assist your dynamic, depending on what it is, obviously, the mother has said. It will assist your case.
Yeah, look, a mother lying in court, I've never heard of such things.
It is a novelty, and it's referred to. In fact, so used to the court are they to people lying that they actually have a phrase for it. It's referred to as the Lucas direction.
Oh yes, I remember that.
And the Lucas direction says that the judge should accept that if somebody has lied and that lie has been exposed, the judge must not then assume that everything else they say is a lie. He must accept the fact that people will lie in isolation.
Yes.
But it doesn't mean that every word that falls out of their mouth is dishonest, untrue, or a lie. The Lucas direction.
Yeah, no, I remember that. Mr. C, sorry to be a Debbie Downer, but we just don't know how the chips will fall. Yes, Mr. C, you are right. But again, the way I want to highlight this point again about the politics is this. Where we are, say, in life, say, working class, low class, whatever you want to call it, whatever position we have in society, it does not make any difference who's at the top. At the top, whatever decisions are made, whatever is done, it does not make any difference down here, I don't believe, in any relative fashion, other than what information is presented to change your dynamics or change your thoughts on who's in charge, who's not. But the point is, I don't think it makes any difference down here. Obviously, Bentley Ryan, this is a different case. But Bentley Ryan,
hurtful.
Mr. Bentley Ryan, bro, he's driving Bentleys, it don't make no odds. But down here, it don't make no difference to us. What will make a difference to us is how we operate in our life, how useful we are, how valuable we are, how much knowledge and information we can consume to improve our life and make changes in our life and elevate ourselves to improve our life. So the key is, I'll say, take all that energy you put out there in the news and the social media and all the things we hear, all the sound bites, put all that energy into yourself. Invest it into yourself. Don't waste it out in all of these things. That's my policy. That's what I do. That's how I operate. Right, here we go. 5-star. Yeah, I was burnt out, was let down, but the positive point of this is the quick turnaround for the next hearing. Also, it's satisfactory that the other party now has to lie in the month of Ramadan. Right, the other thing is this, yeah, with this, right, it's a quick turnaround. But the fact that you went to court, nothing happened, but those emotions, those feelings, that anxiety, that sickening feeling, you got used to that. When you go back, like I said, you now know what to expect. The thing is, when you're feeling like that, and you're going on the first day, and you see some action, you're not 100%, you're not ready for it. Now you've been climatized a little bit to it. You slowly start getting used to it. So when you go back, hopefully you'll be more together. So see it as a positive. Cal, yeah, I brought PA up, but not from the start. What questions is the judge likely to ask at a fact find if I'm just denying them anyway?
I'd love to be able to answer that question for you, Kai, but without actually knowing the details of your allegations, I can't tell you what questions the judge is going to ask. Because, as I say, it's entirely driven by whatever is laid out in front of him. given that you are telling me that the judge is going to ask questions, is that because there is no representation in the room, or are you referencing extra questions that the judge will ask at the end of cross-examination? At the end of the day, the questions that are asked in the room, let me just make a general comment. The questions that are asked in the room should be specific to the allegation in order to provide sufficient information to illuminate that allegation and assist the judge in reaching a decision based upon the probability of balance as to whether that allegation is true or not. Those who aren't familiar with the probability of balance, I will share it very, very quickly. The family court system doesn't operate on the same burden of proof as the criminal court system. The criminal court system says, show me the evidence, show me enough evidence, and then I will cause somebody to be guilty. I will call somebody as guilty. Family court doesn't use that system. Family court uses a system called the probability of balance, which means the question that the judge has to ask himself or herself is, how likely is it, now that I have listened to all of the evidence, how likely is it that this incident, whatever it may have been, happened? How likely is it? And they only have to move 1 point to the left or to the right to decide that either it did or it didn't. That is the probability balance, totally different proof system from the criminal court. That is how it works. So in terms of what questions is the judge going to ask, judges are asking questions that assist them in trying to understand whether the incident took place, yes or no.
Right. Hungry Hippo, Lewis Henriksen, an additional report, two-way report that has already happened. So example, S7 is done, but now court want Kafkas to do an addendum S7 report. Both reports will essentially be one.
Correct. Correct. That's exactly it. They're just adding some extra information to the original report.
Well, thank you for that, Mr. Hippo. We appreciate that. Right. Mr. HY, I remember Mr. HY. Hello, just to update you, had final hearing and judge ordered that I do all 12 handovers to and from West Yorkshire.
Well, I assume when you say you're doing all 12 handovers, I assume it's a monthly handover, I presume, and I presume that the judge is suggesting that you drive all the way to Yorkshire and you drive all the way back. If that's what you're telling me, then I find that quite disappointing. I find that quite sad, because what that doesn't do is demonstrate to the children the importance of co-parenting. That essentially makes you the secondary parent, that you have to traipse the length of the country to go and collect your children. I find it quite sad that a judge has made that decision, and that's certainly a position that I would have pushed hard, and I'm sure you did, that I would have pushed hard in the hearing to say that that's not proportionate.
Yeah, Mr. HY, sorry to hear that, but look, just keep chipping away at it, and keep going. And you've got contact, that's the main thing. It's difficult, but just keep at it. Apologies for the echoing. I think it's when we raise our voice, it's causing more echoing. So just try and talk at normal pitch. Hopefully you can hear us. And yes, going forward, we're going to get the sponge pads or whatever we need on the walls to get this into a full-on studio. It's still a work in progress. All right, how much is the course? That's still being figured out. It will all be online. It's still being figured out. It's not as straightforward as how much it is. There's a lot of aspects to it, so we're still working on that. Yeah, audio is not good. We know. Apologies, guys. Apologies. Right, here we go. Mr. S, how does the court decide how to reduce the number of allegations to be sorted out? Scott, should you want to?
Yes, yeah. I was going to say, if you're heading into a fact find, and allegations have been made, it doesn't matter whether you've made them against mother and mother's made them against you. It doesn't really matter. A set of allegations has been made. The court have to decide which of those allegations are going to be tested And they do that using a fairly simple formula, which is which of these allegations, if they are found to be true, will impact on a welfare arrangement for the children. So let's give you an example. The allegation is that 10 years ago, before the children were born, one parent slapped the other one in a drunken row in the middle of the night. It is highly likely that a court will dismiss that allegation and say it has no relevance to the here and now. It has no relevance to these children. So that's one example. Let me give you another example. It's Saturday night, 5 years ago. One of the children is 3, one of the children is 2, and there is a row in the kitchen. The 2 children are in the kitchen at the time, and they see one parent throw a cup of water, and we'll use that example, throw a cup of water at the other parent. The judge will deem that allegation as worthy of testing. Why? Because the children saw it. Because the children were involved. Because if that allegation is proven to be true, then the parent who threw a cup of water across the kitchen in front of children has to answer for that. Because that deems that parent to not really be thinking about the best interest of the children. So narrowing down allegations is the judge looking at the allegation and saying, do I need to know whether that's true or not in relation to these children? And if I don't need to know, or I don't really care in relation to these children, I'm not going to waste court time by testing it.
Fair enough. Right. Can you please explain 50/50 care orders and the best ways to argue for them?
Okay, a 50/50 care order, sometimes referred to as a shared care order, sometimes referred to as a live with order, is where both parents in the eyes of the court are deemed to be equal. So both parents are the primary carer for those children. Now, the important thing to say about 50/50 care or shared care or live with orders is it does not mean that the 2 parents necessarily have exactly half of the allocated or the available time. It doesn't necessarily mean that. And the reason I say that is because if one parent lives 1 street away from the school where the children go to, and the other parent lives a 25-minute drive away or a 30-minute drive away or more from the school that the children go to, then the court will deem that it is appropriate for those children to stay with the parent who is closest to the school Monday to Friday, because that is about the best interests of the children. So they're still saying both these parents are equal, but in order to facilitate the schooling arrangement, the children stay Monday to Friday with parent A, might be mum, might be dad, with parent A in order to facilitate their schooling. So shared care orders, 50/50 orders, live with orders do not necessarily mean that each parent gets exactly 50% of the year made available for them to be with the children. It is about what is in the best interests logistically for the children in terms of their schooling, as to how it is that the calendar is broken up.
Yes, and I think obviously if you live within the same area as the children, walking distance, school and back and all that, it gives you a better chance. So if you want that and you are in a position to make that sort of move, obviously it's not for everyone, but if you can do that and you think you can pull it off, that might be a strategy you want to adopt. So yeah. Right, Mr. C. JDad. 50/50, a big discussion. One thing I remember reading, however, was that the practice direction states something along the lines of, above all else, parents to be on a good, amicable footing.
Mr. C has done his homework. He's absolutely right. The comment was actually originally made by Sir Andrew McFarlane in a case about 15 years ago, where Sir Andrew McFarlane, who is the current president of the family court, said that 50-50 orders or shared care orders or live with orders will only work if the parents are amicable, because they have to work together to make it work. So they have to be on speaking terms. They have to be able to communicate with each other. If the parents are still doing this the whole time, 50-50 will fail, and it will fail dismally, because one parent will try and get the upper hand over the other. So Mr. C is absolutely right that the practice direction for a 50-50 order, and indeed the wording, the comment of Sir Andrew McFarlane, I'm going to say 2015, 2016, I'm happy to be corrected on that, was that the two parents have to be amicable. Otherwise, a 50-50 order is simply going to fail at the first fence.
Yeah, Mr. C, well done for that. Appreciate that. Right, Mr. Brooks, thank you. So the judge will decide which allegation and let us know, or do we need to suggest to them? In your example, throwing water, how does he pay the price?
Okay, yes, the judge will decide, and that's decided at normally, the normal forum is what we call a PTR. And a PTR is a pre-trial review. So it's sometimes a 1 hour, sometimes a 2 hour hearing that takes place before the scheduled fact find, where the judge looks at the allegations and says, I will hear number 1, I will not hear number 2, I will hear 3 and 4, I won't hear 5, and he narrows it down, because otherwise there are potential. I've been in pre-fact finds where there are 40 allegations on the table, and that's 10 days of court time, which is ridiculous. Wow. Yeah. So they narrow it down as best they can, and the judge will do that with you. He does accept arguments on it. He doesn't accept discussion on it. So it's not just him sat there dictating. He will listen to the arguments being made by both sides as to why they support or not a particular allegation. But ultimately, the decision is his.
Right. 5-star. This is something so simple, but if there are accusations, wouldn't the courts question why they are brought up now after separation, yet when together? You didn't do anything then.
It's a very valid point. And the reason they're brought up now is because you're in conflict. I've stopped asking that obvious question after the number of years that I've been doing this. I've stopped asking the obvious question, which is, how is it it's taken you 10 years to bother to bring up whatever this episode is? I've got some absolute gems of stories which will feature in a book some point later, where parties have suggested that an incident happened and it's taken them between 5 and 10 years to report that incident to the police. And then when you look at the timeline, you see, well, yeah, I can see what's happened there, because since then, you've now split up, you're now in a fight, and you need to get your ammo in. So you suddenly start dragging allegations out. Something happened 5 years ago, something happened 10 years ago. I had a matter a number of years ago where and it was the father, I'll be perfectly honest, I was representing the mother, and the father was pulling out allegations about the mother's behavior 24 or 25 years ago.
My God.
Let me give you some context. At that point, mother was a teenager. Mother was 13 and 14 years old, was a bit of a wild child. And the father was bringing those out and trying to get the court to take those on board as serious allegations. So why do people drag it out? Because they're in a fight. And when you're in a fight, you pull out what you've got.
Yeah, look, it's human nature, to be honest. They're going to fry the dirt, dish out the dirt when you're cornered, and family court seems to be the place where all the dirt comes out, unfortunately. I mean, you really get to know your missus in court and find out who she really is, let's be honest. Right, Maximus, can we email the court to change the existing shared care without C100 application if we want it in a court order?
Okay, let's just dismantle this question, make sure I understand it, Maximus. So what you're saying is you have an existing order in place and you are looking to make some changes to it. Now, if both of you agree to those changes, both parties are agreeing to the changes, but you just want them enshrined in your order, then you can go back to court and ask for those changes, but you are going to have to go under the premise of a consent order. So unfortunately, you are going to get caught up in the whole application process because you can't. Once your matter is closed in court, unfortunately, they're not just sort of hanging around waiting for you to come back to make your adjustments. It doesn't work that way. When your order is drawn and your order is final, that is it. As far as the court's concerned, its involvement is done. If you want to make changes to that order, you have to come back under perhaps a variation application or indeed under a full C100 application in order to make those changes, even if you both agree them and they are consented. There is a process, I'm afraid.
Right, my guy, numero uno, Jada. The best way to argue for shared care is to convince Cafcass that's the best for the kids, assuming S7 ordered.
I don't disagree with that comment. Keeping Cafcass on board during your proceedings is an important thing to do if you possibly can. Because they are your friend in the family court. They can also, unfortunately, be the entirely opposite. But if you can convince Cafcass that shared care is an appropriate thing for the children to do, is a child-focused thing to do, they will build it into their recommendations.
Absolutely. Try and get whatever advantage you can. That's the bottom line. Right, where's my guy? Mr. X, can you be found guilty of something in the fact find that is not domestic abuse, i.e., you breach your NMO? Will you be branded a domestic abuser if even one allegation is proven?
Okay, there's a couple of questions there. So, can you be found guilty, as they would not really use the phrase guilty? Can your allegations be proven in a fact find? That's the phrasing that's used, even if they're not directly domestic abuse related. Yes, their allegations aren't necessarily domestic abuse related. 99% of them are. If you breach a non-molestation order, it's unlikely that that would be brought into a fact find. That would be a separate issue. The court may choose to consolidate it to try and save some court time. But a breach of a non-molestation order would not be brought out as a finding in a fact find. That's a slightly different mechanism. But here's the $64,000 question. Will you be branded a domestic abuser if even one allegation is proven?
Yes.
Yes.
You will, unfortunately.
You will. Unfortunately, a domestic abuser is somebody who has been found in the family court or in the criminal court to be guilty or proven of an allegation of domestic abuse, regardless of how perhaps trivial that domestic abuse allegation is. And so, yeah, you will carry that branding then from the moment that that allegation is proven.
Absolutely, yeah, that's it. It's not good. Right, numero uno, responding to a gossip. That was definitely a thing at one point. I mean, parents need to be on good terms for 50-50. But I'm fairly certain there has been further development on this sense. Parents' relationship is just one.
You're correct. It is just one element that the court explores, because I have been in proceedings where we have struck shared care orders despite the fact that the parents absolutely despise each other. And we've managed to do that by getting the parents to agree some sort of mechanism by which they communicate. And that might be through a parenting app, that might be through a third party, because both of them respect the mother or the mother-in-law, perhaps, as an example. And so it's not a given. It's not 100%. If you aren't amicable, you're not getting a shared care order, providing that you can, albeit reluctantly, but provided that you can agree a mechanism by which you can communicate with each other, be that through a parenting app or whatever, then the court will still consider a shared care order, because at the end of the day, their first priority is to consider the best interest of the children. And if a shared care order is in the best interest of the children, they are minded to grant it, to direct it. But the court has to have a confidence that it's not going to fail at the very first weekend.
Right, okay. Right, Mr. Cow. In that case, can I agree to a form of contact before we go into the fact finding, like indirect? Currently not seen my two kids in years, but I'm worried it's dragging out even longer waiting for a fact find.
Okay. You have the opportunity throughout your proceedings to agree arrangements with the other party. In my experience, if you are heading towards a fact find, the other party becomes, particularly if the allegations are against you and there are no allegations against the other party, I think you will find it incredibly difficult to strike arrangements, contact arrangements, because there's no objective for them. There's no incentive for them to have to be reasonable with you, because they are about, their belief is, and let's be honest with each other, their belief is that they're about to slaughter you in the family court in a fact find. So why would they be reasonable and give you a contact arrangement, be it indirect or whatever? But that's straying a little from the point. The point you're asking is, can you strike a deal ahead of a fact find, during a fact find, after a fact find? Yes, you can. There's always opportunity for two parents to strike a contact arrangement, which is in the best interest of their children, if both of them can agree to it. And the court will always listen to that argument. And the court is, the primary objective of the court, as I've said many times, is to reconstitute face-to-face relationships between parents and their children. So the court will rarely stand in the way of a contact arrangement that's been agreed between two parents, unless the court believes that the severity of allegations that have been made warrant no contact until such times as those allegations have been explored.
Right, let's move along. Right, Maximus, here we go. Where are family court proven allegations recorded which are not convictions? Is there a register for that?
No. Family court, let's not forget, family court is a private law arena. So in technical terms, a family court proceedings is a private matter. It's an argument, it is a dispute between two parties. It is not available to be discussed outside of that courtroom. It's not available to be broadcast outside that courtroom. So by virtue of that, if there is a fact find within the confines of that private law dispute, and allegations are proven within that fact find, there is no register whereby those findings are listed. There's no sex offenders register, there's no domestic abusers register, there's nothing on a par with the criminal system, which obviously builds you a criminal record, because it is a private dispute.
Yes.
Yes, so there is no
Yeah,
register.
there's nothing, look, there's nothing to worry about. It won't be in any register. Like I keep saying, just don't take it too seriously. You know, when you get a non-mol order first servant, that word non-molestation order, you just read that, you get panicked just because of how horrible it sounds. But in the real terms, as far as registers or anything like this is concerned, it doesn't go on anywhere. It's not going to follow you around ultimately, so don't take it too seriously. Right, Mr. S, I guess that is why some parties throw up 100 allegations and hope one of them stick. Have you seen in your experience that many people are found guilty of just one allegation? I think I can answer that yes.
That is a yes. In my experience, and I can say this, I'm just sort of reflecting now, but I can say this pretty categorically. I have never been in a fact find where not a single allegation was proven. The court, when the court makes a decision to stage a fact find, the court is pretty confident that at least one of those allegations is going to be proven, because that justifies the fact find. So I can say confidently after all these years of doing this that I have never been in a fact find where not a single allegation was proven.
There you go. Right, let's move along, guys. Move along. Right, Mr. A. During my Cafcass interview, I said 50-50 was my preferred, so it would not disturb the kids, and the ex can also have first pick of the holidays. When the safeguarding letter came out, there was no mention of it.
Okay, that's not unusual. The safeguarding letter, just so we're all familiar, the safeguarding letter is the first engagement by Cafcass with your proceedings. It is a very brief conversation with mum and a very brief conversation with dad in order to understand what is going on. Why is it that we find ourselves in court? Because the safeguarding letter obviously is written by a Cafcass officer who has a very limited time to produce this task.
Yes.
It is a very short and pain in the bum task for Cafcass officers to complete a safeguarding letter. So because we're dealing with individuals, some individuals will be fuller than others in terms of what they produce in the safeguarding letter. In terms of your matter, where you said you've mentioned shared care as being your preference, but it's not been referenced in the safeguarding letter, don't be concerned by that. That can be for 100 different reasons. Either that the Cafcass officer just didn't bother writing it down because they just produced a very short, sharp, concise safeguarding letter, or the Cafcass officer felt it might be a little premature to make that comment at this stage. So there's a number of reasons. It doesn't mean the matter is closed. You've offered it up. It hasn't been noted, but you've offered it up, so the process has started.
Yes. Long way to go still, Mr. A, I think, if you're there. Carol, thanks a lot. You're welcome. That's why we're here. Again, reminder, we're here every Sunday, 8 p.m. Doesn't matter where I am in the country. My laptop's with me. We'll dial in. Mr. Ryan will dial in. We will be here every Sunday. Help support you guys.
Hit the like button. Hit the like button.
Yes.
Right. I'll say that because I just have.
Oh, nice one.
Yeah.
Listen, appreciate that. Thank you. Glad to see you're on it. You're switched on.
I'm on it.
Right, Mr. A, is it normal for mums that stay with the children to say that the children have been mentally upset by that, but when checking with the doctors up until the separation, nothing was noted? How can this be? Now, I think, yes, this is very normal. It's a very normal strategy, very normal tactics, textbook. This is like, do you know what I mean? What do you reckon?
It is. I mean, again, we're going back to my comment about lying, really, aren't we?
Mum lying, really?
Well, parents. So let's be broader than that. Parents who are in family court, ultimately, they are in a competition.
Yes.
You know, they are trying to win. And all right, well, I'm not a huge fan of suggesting that you can win in family court, because that's not what it's about. But they are in a competition, and so people lie. People exaggerate, people deliver a false narrative that suits their story. So if it's that mother is making comments in family court about the fact that the children have been mentally harmed, damaged, distressed by how it is that their father has been, but funnily enough, none of that features on medical records, that's no surprise. That isn't a surprise.
Yes. Yes, I think, look, guys, when you enter the system, right, like I said, it is a competition, it's a fight. They're going to try and hurt you. They're going to try and take every advantage. And what I've noticed with all of the fathers that I deal with predominantly, what I've noticed is most fathers are walking into this with this sensible hat on, that if I be reasonable and sensible and do the right thing, the other party will do the same and we'll all come to a good, reasonable conclusion. This is a fantasy. Soon as that separation happens, or the relationship's rocky, you need to remember that they're going to come at you with everything. So you just got to brace yourself for that. They're going to come at you there. You'd be naive. Okay, what I'm trying to say is you'd be naive to think that it be a walk in the park and, you know, a little kiss goodbye and you walk, you know, go your separate ways. I think you'd be naive to believe that. So yes, this is normal. Expect this. This is all from the playbook. And he follows up with use against that for finance and children. Absolutely. Be used for any means necessary. It will be any advantage will be taken. And if they've got solicitors, they will be advised accordingly to get themselves in the best position possible. Again, secure the children, you secure everything else, and in order to do that, you paint that out to be a monster. We know this. This is standard playbook. Right, where are we? I'm losing track. Right, here we go. 5-star. What if both parties stick allegations against each other and each party are guilty?
That can happen. That can happen where a fact find rules that both parties are guilty of one or more of the allegations. All that does is it levels the playing field. The process is still the same. CAFCASS still get involved and consider the findings that have been made, and consider those findings then in terms of their severity, in order to decide what's best for the children. But it's not unusual for cross allegations to be proven in matters and both parties to find themselves guilty, in inverted commas, of being an abuser. Not unusual at all.
Right, here we go. Right, let's move along, guys. I'm going to start flying through these now. Why do solicitors advise against the dad seeing the children? Is it that there will be allegations?
Why do solicitors advise against the dad seeing the children? I'm assuming this question is why do solicitors advise mothers to stop dads seeing their children? And that comment could be flipped to solicitors advising fathers to not let mothers see the children. I like to hope that solicitors do not advise without sufficient grounds that their client doesn't allow the other parents to see the child. If that was happening, and let me just say as an aside, I think it probably is happening, but if that was happening, that would sadden me greatly that solicitors were giving that advice. The solicitor, their role is slightly different from how I conduct proceedings for my clients. Their role is a little bit more gladiatorial than I am, a little bit adversarial, which means they're looking for the win.
Yeah.
And so they will advise their client on the tactics that will move you closer to the win. And one of those tactics is deny the other parent access to the children, because over time you can undermine the relationship. I find it a pretty vulgar tactic. It's absolutely not child focused, but it happens.
Yeah, I think that just highlights again, which I forgot, the difference between solicitors and Mackenzie services. Ultimately, the solicitors come at this from a different angle. They want to win. It is gladiatorial, and they want to, I suppose, best position their client in a position of power and leverage. And in order to do that, you have to get dirty. As simple as dirty tactics. It's not a fair fight. If you come again in life, if you walk in somewhere thinking, like I said, it's bringing a penknife to a gunfight sort of thing. Do you know what I mean? It's that sort of. Fathers are showing up, penknife to a gunfight. Listen, it's going to get dirty, and you know. But that highlights the difference between the mindset of the solicitors and Mackenzie services, or that's how it should be at least. Right, Mr. F, the judge called a fact find without reading our allegations. Is that right? He mentioned he couldn't see the bundle and had not read anything.
If that's the case, that's quite disappointing. I surmise that within the safeguarding letter from CAFCASS, that domestic abuse allegations were raised within that. And I surmise that they were of sufficient severity that the judge concluded that a fact find was going to be necessary in any event. I'm always quite disappointed where a judge says in open court that he hasn't read the bundle and he's making decisions on the hoof, off the cuff, on the wing, whatever phrase you want to apply. I find that undermines the integrity of the court if a judge is saying, I've made this decision based on the fact that I haven't read anything, I just quite fancy it. So that's sad. That's sad. I would like to hope that that judge, despite his comments or her comments, hasn't made a decision to launch a fact find based on nothing at all apart from what they feel. I trust there's more substance than that. If they haven't, then that does fly in the face of the directions of the court, because over the course of the last 18 months, all judges within the family court system have received a directive from the president to say, I wish a reduction in the number of fact finds. We are rolling out fact finds with the pace of sweets, and we don't want that. So there has to be a purpose, a real purpose to a fact find before they roll one out. So that particular judge, SS, in your instance, I'm a little disappointed to read that.
Yeah, well, at least that's good news. At least someone above is saying, look, I mean, a while ago they said we're dishing out too many non-moles, and I think they had to claw them back a little bit. Now it's the fact find, so someone is looking at it. That's a little bit of good news, I suppose. Right, let's move along. Let's fly through some of these. Right, Mr. C. Sadly, the DV industry is fast becoming a farce, as things such as a household budget being in place by a provisioning male can subsequently be spun as financial control when the bar is set so low. I 100% agree with you, Mr. C. A conversation about domestic budgeting, forget the courts, mate. I was in a relationship, and when we talked about just general household budgeting, that was seen as me being tight. It's just bizarre, very bizarre.
It's very true. It's very true. Financial control is becoming a little bit farcical in the family court, and a situation like, and I'm not looking to be stereotypical, but like in the home, dad is the breadwinner, dad is earning the money, consequently, dad is saying to the mum, look, this month, we just need to keep our belt tight. We just need to make sure that, that we're not going mad. Mother brings that into family court and says, dad denied me the essentials. And that's a reality.
Disgusting. Right, Mr. Cow to S. Did you tell the judge you wanted a fact finding, or did you dispute it? All right, we'll move along. Like, numero uno. 5-star. If allegations found against each other, the court will likely conclude there was mutual abuse. They will decide the outcome based on best interest of kids.
True.
And he follows up with, never mind solicitors advising father not to see the kids. Most professionals, even before court, will suggest it off the record because they're ill-advised and believe whatever mothers say. SSGP police. Yeah, I feel your pain, brother. I feel your pain. Right, numero uno. AS, look into KVK and PD12J and make representation to the court to reconsider where the fact find is necessary.
Okay, it's a brave move. Let's just clarify what they are, just for the purposes of those who don't know. We'll start with PD12J. PD stands for practice direction. The court is run on a series of practice directions or rules, and practice direction 12J applies itself to themes of domestic abuse within proceedings, and it explains to the court and to the judge how it is they conduct proceedings where domestic abuse is a theme, such as the fact that two parties can't question each other. So that's practice direction 12J, and that's numero uno's reference to it. And K versus K is a piece of case law, is a piece of precedent case law, which explored the proportionality of a fact find. I take on board numero uno's comment that you should make representations to the court as to whether a fact find is necessary or proportionate. That, without full legal representation, that would be incredibly challenging, because the court, the judge, will very quickly shoot you down with case law and with precedent unless you have to hand, off the top of your head, counter arguments. So it is very difficult, regardless of what the matter is, it is very difficult to challenge the decision of the court, particularly if you're unrepresented.
So yeah, so basically you can do it if you got money. Ultimately, you'll have barristers, you'll have some firepower, and then champion. Otherwise, on your own,
It's hard work.
tough old road. Right, guys, one more final comment on the night or question. Ask or an appeal. Is that a question? Is that a question?
Or appeal, yeah, again, I mean, I've talked before, I'll just touch on this very quickly. I've talked before about appeals. Appeals in the family court are like trying to win the lottery. The odds are so stacked against you. The number of appeals that are successful in family court is equal to the number of people who win the jackpot on the lottery.
Okay, right, we've got a few more comments. Go through these few. It is difficult, I agree. Okay, fair enough. Right, Mr. C, very interesting comment. On a positive note, I truly believe given enough time, Matt has brought the line. Low birth rate, marriage rate, male and female relationships, fathers and kids' lives, single moms, all the dots will join. Yes, Mr. C, sometimes you wonder where are we headed as a society? It does make you think. Right, Maximus, in a divorce case of a foreign marriage, nikah, can the conditions of nikah be classed as pre-nuptial agreement in the UK as it was written agreement as to what will happen in the case of a divorce?
Oh my word. Prenuptial agreements.
Oh, you're talking about prenups, yes.
Okay, prenup. The problem we have with prenups here in the UK, well, here in England, let's focus on England and Wales because they're dealt with in a slightly different way in Scotland. So in England and Wales, prenups are challenging. Getting a prenup to stand up in court is a difficult thing to do. It's not impossible. It's not impossible, but it is a difficult thing to do. I think, from my experience, you will struggle to get a nikah to stand in an English family court or a Welsh family court. I think you will struggle to try and present that as a prenuptial agreement and have it recognised by the court because it is a document that's been drawn outside the court system. It's a document that's been drawn outside the English or Welsh legal system. Consequently, the court, I think, will view it as a vacuous document, i.e. of no relevance.
No, but the thing is this, yeah. Okay, so it was a foreign marriage, right? Yeah. So he went abroad and got married, right? In order for the spouse to come over, either she came over on a spousal visa, and then it's automatically registered once you enter the UK anyway. That's from what I understand. So if you brought her, so let's say you went to whatever country, got married, came back, and then brought her over, even though in that other country you only did your religious ceremony, so you just did a nikah, right? But when he brings the missus over here, like that marriage is automatically registered because she's come over as a spouse.
The marriage may well be registered, but the prenup, which is what we're talking about here, the fact that when the nikah took place, there was a document, and I've seen these documents time and time again. There was a document that described what might happen with gold and what might happen with the return of dowries in the event of the failure of the marriage, etc. To get that to stand up in an English court, I think we will struggle.
Yeah, fair enough. Right, we've got some positive comments, so let's end on a positive note. Thank you, guys. You've been very helpful and clear. Yes, guys, apologies for the sound and the echo again. It's a work in progress. I've got plans for the studio. Once I leave this village, Mr. Ryan is going to get the sponge pad, the echo pads. I'm going to have a list of jobs for him where this has got to be kitted out further. Right, here we go. So, Mr. D, check this out. To end on a good note, I would like to share with you guys that I will be seeing my child after interim contact was granted in a contact center. Last time I saw a child was when she was 3 and now she is 5. Listen.
Wonderful. Absolutely wonderful.
It's a great news. It's been 2 years. I feel emotional for you because it's been 3 years since I've seen my children, and I can't imagine the emotions that you might be going through. But look, just embrace the moment. I wish you all the best. And I'm sure it's going to be a very emotional moment. So listen, man, listen, my heart goes out to you, brother. All the best.
Yeah, absolutely, absolutely.
Right. How's that? How that's great news. How did you manage to get the interim contact? Well, I don't know if that's like a negative comment.
No. I think it is. I think it is a reference. I think interim contact is available. As I say, you've got to fight hard for it. So the fact that you are mid proceedings, if you managed to get some contact and seeing your little girl, it's just wonderful. And we're not gonna put any more spin on it than that.
Yeah.
It's wonderful that you're going to get to see your little girl.
Exactly. Look, she was 3, she's 5 now. She's still young. You've got time. You can build on this. You can work with this. Look, we can never forget the reason why we're here. The most important thing is these kids. Look, we can say we're victims and we're upset and the system ain't right and this and that, but these little kids, they deserve a chance. They are the next generation. They're going to be here when we're gone. So look, we need to make sure they get a good solid upbringing, they get love from both parents, and you are a part of their life and you input into them. So if you've got that opportunity, focus on that and build on that. Right, a few more comments have come in. I'm going to quickly go through some of these guys and we're going to slowly just bring this to a close. Right, which date is the date of marriage, the nikah or the court marriage? Right, is that a question referring to the other fellow?
Yeah, well, I'll answer it how I think it's asked. The court, when you come to financial proceedings, the court recognises the date that the marriage was registered in England and Wales. The date of the nikah is almost irrelevant.
Okay, yes. Let's highlight nikah is almost irrelevant, and for those brothers out there that are getting married, just get your nikah done. Don't get carried away. Don't get the government involved. Stop getting registered. Just do your nikah only. That's it. Thanks, guys. Been very helpful. You are welcome. Numero to DGS. Congrats. Yes. Congrats to you, brother. Well done, DGS. Wow, well done. It's a struggle. It was deemed in the interest of the child. This is what I'm talking about, guys. If you can pull it off. There are stories. I mean, obviously, he's been through a journey. There has been difficult moments, but you can get results like this. You can build on this. So stay focused. Eyes on the prize. 5-star. Congrats. Happy for you. Thank you, guys. It's been a long road. Absolutely. Maximus, thank you very much. You're welcome. All right, here we go. Right, Hungry Hippo. Before you go, please tell us more about the course, please. Duration, course structure, classroom or online, and price, please. Do you want to give any more comments on this?
We'll give a little bit more. We're keeping our powder dry. That's a great phrase, because we are still just in advanced planning stage. So we don't want to give away all the detail at this stage. But this is what we can tell you. We will tell you this. The course is modular, so the course is online. So you will get access. Anybody who chooses to take on the course will get access to a catalogue of modules. And those modules cover every aspect of child proceedings, from the most trivial points, such as who is the judge, what is the judge, and how do I talk to the judge, right the way through to how do I defend myself against allegations in a fact find, and all points in between. But it's modular. So it's a series of online modules. So you do it at your own pace, you do it at home or wherever you choose to do it, on your phone or wherever. But that's how it's conducted. In terms of duration, if you sat and did the whole course end to end and didn't ever get up, it would take you, in my view, probably about 3 weeks to complete it. Because as I say, there are a lot of modules, because we have sat and dismantled the family court, and I wanted people to be able to read and see and learn from a module that covers every aspect, every single element, every single possibility of something that will happen within family court, down to modules where this is how to pick up this module when it's all going wrong. And this shows you how to get it back on track. So we really have covered everything. So online modules done at your own pace. You essentially buy access to the modules, and away you go, and you can do them in any order you like. You can do them at your own pace. That's entirely up to you. There will be opportunity for you to engage with us directly during the course of completing those modules, but we'll explore that in more detail when the course is out there. In terms of price, we're keeping that quite close to our chest at this stage, but to give you an idea, because I think it's fair that people do have an idea, if you take what we refer to as the platinum version of the course, which is access to all of the modules, plus also access to me and my team, and access to Farouk for his coaching skills and his coaching encouragement. That price point is going to be around about the £4,000 mark for that whole concept to be made available to you. And there's obviously a payment plan that we put out to people, so we don't expect anybody to produce £4,000 instantly. Hopefully that gives you a little bit more idea. It'll become more obvious over the course of the next few weeks. We are going to start talking about it quite extensively on social media, on both my channel, which is currently going through a revamp, and also on Farouk's channel, which obviously we're on currently. There will be, in terms of the live streaming, we are going to blend the live streaming over the course of the next few weeks in order that it streams on Farouk's channel and on my channel at exactly the same time, in order that different audiences can buy into it for whatever reason they choose to do so. So that's going to be quite interesting, because people on my channel tend to come from a slightly different angle. So that's going to be interesting for all of us. So hopefully that's given you a little bit more insight. But the primary purpose of, he presents the logo. The primary purpose of Family Court Mastery is to ensure that nobody has to go through the family court alone, unsupported, and in the dark. That is its primary purpose.
Yes, I was going to add to a little bit to what Mr. Ryan said. So you see all the questions we answer on a weekly basis, all the little nuances, details. The course is intended to cover all the little aspects that you wouldn't know. When you're walking along, you don't know these are questions all you guys are asking. So we're taking all of this information, all of these questions, all the little nuances and details will be covered to your best armed with all the knowledge possible. And like I said, on the Platinum package, we'll be doing the coaching. There'll be weekly Zoom calls with a team, with our cohort, and we'll be answering individual questions for individual cases to give you that support and backup you need to see the process through, to give you the best chance possible with the best value for money to get the best outcome possible ultimately, because we know what the system's like, we know what the journey's like. Now, then this is a product that we're hoping that can help people get from A to B, start to finish, without breaking the bank, and the best possible outcome. So that's the idea, and obviously there's a lot of work still to do behind the scenes to get this launched. So we're working on it, and we're going to get it. As we progress, we will be revealing more information and details about this. Guys, thank you for watching. Like, subscribe, follow, and share. It's been another great stream, great engagement. Share the link, spread it out. And if anyone's going through the system, direct them to these lives every Sunday, 8 p.m. And we will be live, like I said, on Disqualified Dad as per usual. And going forward, on Mr. Ryan's channel, which is getting a revamp, will be live streaming on both channels simultaneously. But thank you for watching. We will see you on the next one.
See you later, guys.